The success of any alternative dispute resolution process depends on how well the local legislation and the courts lend support to the essence of that process. As we know, mediation is essentially consensual, that the parties retain control at all times over the process and the outcome. The party autonomy and self-determination are the very nature of mediation. The Mediation Act recognizes party autonomy, emphasizes self-determination as paramount features of mediation, and sets out a facilitative, supportive role for courts. Speaking of party autonomy, the parties are free to commence mediation as they like. They can decide to agree to mediate or not mediate. The only exception appears to be the court's discretion under Section 7 to refer the parties to undertake mediation. The parties are free to continue with mediation or withdraw from mediation as they like. There was some prohibition against withdrawing from mediation until after the parties attend 2 sessions of mediation, and a discretionary cost sanction for such withdrawal in the original bill. But the amended bill removes that. The parties can agree not only on the procedure of appointment of mediators, but also on the specific mediator himself. In fact, the party preference is a factor even when a mediation service provider appoints the mediator for the parties. The parties get to decide the place, the language, and mode of mediation, offline or online. They can effectively decide which court should have territorial jurisdiction over the mediation, how the costs of mediation should be borne or apportioned, and whether to extend the time to complete mediation and whether to even register settlement agreements. The parties are, even more importantly, free to settle or not settle their disputes after going through the mediation process. The freedom to self-determine. Even though the court refer the parties to undertake mediation under Section 7, there is no obligation to settle. In fact, the Act directs the mediator to expressly inform the parties that he is there only to facilitate the process of mediation, that he will not impose any settlement, and that he will not give any assurance of settlement. So there is almost absolute party autonomy at all key stages of mediation, at the commencement, during the pendency, and at the termination. The Act deserves a lot of credit for that. Now, coming to the role of courts assigned by the Act, you must remember that the last thing you want in an alternative dispute resolution process is a party running to the court at every possible step, trying to delay or sabotage the process. The drafters of the Mediation Act appear to have this in mind when they set out a facilitative, a very supportive but important role for courts in mediation. As such, the courts have the power to refer the parties to mediation at any stage of the proceedings before it. That's Section 7 reference. The courts have the power to provide suitable interim relief to protect the interest of any party in those mediations undertaken pursuant to Section 7 reference. The courts have the power to refer pending compoundable offences, including matrimonial offences, to mediation, which are not otherwise fit for mediation. It must, however, be borne in mind that the outcome of such mediations, those mediations which are specifically referred to mediation, which are compoundable in nature, will have to come back to the court for its consideration to be dealt with in accordance with law. The courts also effectively determines the territorial jurisdiction of a mediation. Every mediation, says the Mediation Act, shall be undertaken within the territorial jurisdiction of the court or tribunal of competent jurisdiction to decide the dispute, of course, subject to the parties agreeing to the conduct of mediation outside that jurisdiction or online. This is critical. This deemed jurisdiction is critical when it comes to the enforcement and challenge of mediated settlement agreements. The most important role of courts in mediation, however, comes after the mediation has ended, when a party seeks to enforce or challenge a mediated settlement agreement, where a successful outcome emerges from mediation in the form of a settlement agreement, and where one party refuses to comply with the terms, the innocent party can now approach the court for the enforcement of that agreement. A party may also challenge a mediated settlement agreement on certain grounds in a court. On party autonomy, self-determination, and role of courts, I have 4 comments to make. First, the power of courts to refer the parties to mediation, as I mentioned earlier, is an aberration to the rule of party autonomy. But there are 2 sides to this. On one side, the courts have no business, should have no business in compelling the parties to mediate where they have not committed to mediate in any way. On the other side, this additional push, this compulsion that require the parties to attempt mediation may in real world be a boon to the parties who may shed the initial reluctance and mediate and who knows, settle their disputes. At least it opens up the possibility for a resolution. In principle, it may be wrong, but in practice, it may work. The courts are unlikely to use their power under Section 7 indiscriminately, and in any event, the parties can always decide not to settle, turning this compulsion to mediate into a minor inconvenience. Second comment I want to make is while Section 7 reference could arguably be used to enforce an agreement to mediate, it would have been a lot clearer had a separate provision be inserted in the Act to empower the courts to stay the proceedings before it or refer the matter to mediation if there is a breach of an agreement to mediate. That would have been clearer. Third point I want to make is that the courts have the power to issue a suitable interim order to protect the interest of the parties. This can be very useful to the parties to maintain the status quo or to preserve the subject matter of dispute. However, curiously, this curial power appears to be limited to mediations undertaken pursuant to reference by courts under Section 7. There is no reason why such support, the interim protection, should not be extended to other mediations as well. And final point I wish to make in this regard is that there was some mandatory pre-litigation mediation, a highly criticized provision in the original bill, and it has been effectively removed from the Act. It is now made optional. Whether retaining the concept of pre-litigation mediation even as an option makes sense is a separate question, but the Act importantly takes away, in tune with the party autonomy rule, the compulsion to mediate from that provision.